Good morning, everyone. If you could please be seated, we're going to get started. Welcome to Vermont Law Review's 17th Annual Symposium. We are delighted to see all of you here, whether you've flown across the country to be here this morning, or you're a student who wakes up and comes to campus every day. We should have a great series of discussions today on U.S. media law and journalism and what it means to protect our democracy's safeguards. Vermont Law Review has the opportunity and the privilege every year to host a symposium just like this one that focuses on relevant and timely topics. It's a really great opportunity for us to bring in professionals and academics from across the country here to our small campus in Vermont. Today, you're going to hear from practicing attorneys who steep themselves in Foia litigation on a daily basis, those who dedicate their time focusing on national security issues. We'll talk to you about what implications there are for whistleblowers and those who leak information to the press. You'll hear from journalists in the field who know firsthand what it means, what U.S. media law means, for their ability to gather information and to disseminate it to readers and viewers like you and me. And our final panel will zero in on fake news, which in and of itself is not only a fascinating topic, but again, extremely timely. This riveting program that we have planned for you today would not be possible without all of the panelists and moderators who made the trek up to Vermont, to our small corner of the world, to share with us their expertise. And we are very grateful here at Vermont Law School and the Law Review that you have chosen and you've taken the time out of your busy schedules to come and share with us that knowledge. Similarly, nothing would have been possible today without our two symposium editors, Sylvia Duluc-Silva and Elliot Rosenbaum. They have dedicated their time since the spring, when yes, snow was still on the ground in Vermont, to coordinate this wonderful event and make it into a reality. So in welcoming them to the stage, I encourage you to give them a warm round of applause for all of their hard work.
Welcome, everyone. My name is Sylvia Duluc-Silva, and I'm so glad you're all here this morning. This year's Law Review Symposium topic was proposed by my co-symposium editor, Elliot. Media law is a foreign subject to me, but lately it's become more relevant with the new administration and the First Amendment rights that have been violated in my home country, Venezuela. For someone that doesn't even watch the news, my hope for putting this symposium together is to learn about media law and to learn how to best keep informed. I hope you enjoy the symposium as much as I've enjoyed planning it. Thank you and welcome.
Hi, good morning, everybody. Again, I'd like to reiterate how glad we are that you all came up to Vermont Law School to address some pressing issues. So while we too are the symposium editors up here, and it was our job to make sure the event happened, the event is really the result of a lot of time and effort put in by a large cast of people over several months. So a huge thanks to our faculty symposium advisors, Professor Stephen Dycus, round of applause, Professor Jennifer Todd, and Professor Peter Teachout. We'd, of course, as well like to thank all of our panelists for the time they devoted out of their busy summer schedules to help bring the event together. And Vermont Law School's Head of Communications, Mary Ellen Applequist, who, yes, she graciously opened up her office to all my wanderings over the summer and answering frequent questions. And we'd also like to thank our Law Review faculty advisor, Hillary Hoffman, and our incredible editor-in-chief, Amanda Quinlan, as well as all the staff editors at the Vermont Law Review. So reflecting on why we are hosting a symposium on this topic, we just have to take stock, I think, of the incredible freedoms we enjoy here in the country that others, frankly, do not. We can assemble with, discuss with, and dissent with whomever we please. We can educate ourselves on almost any imaginable subject, and tell others of our findings, we can just talk with each other without fear of repression. So we're very lucky, but luck is not enough. And every now and then, either by happenstance or design, these freedoms are threatened. Whether that threat comes from a foreign adversary, an overly bureaucratic or just plain overworked administrative state, or an antagonistic executive, or simply a sudden change in communication technology, we as citizens are called upon to breathe new life into our First Amendment freedoms and their legal and social protections. So that might be an overly ambitious goal for a one-day event. So let's not waste any time getting started. I hope you will join me in giving a warm welcome to our very own Dean Thomas McHenry.
Thank you, Elliot. Thank you, Sylvia, Amanda, very much. I'm new to Vermont Law School. I started work here about 2.5 months ago, and I left a legal practice of 30 years in Los Angeles, California, to come to Vermont because I believe so deeply in the mission of this school, its mission-driven focus, and the engagement of its students and its faculty on important environmental and other issues. And I can't imagine an issue more important than the one that you are taking on today. So I promised I would only say a few words, and that's what I'll stick to that. And welcome you here to Vermont Law School, to South Royalton and the great state of Vermont, and hope you have lively and engaging discussions. And I'm delighted to turn this over to Professor Teachout. Thank you, Peter.
Well, what a privilege it is for me to participate in this conference today. And I too would like to express my appreciation both to the Law Review staff and also to the panelists who have traveled far and wide to get here and participate in the discussion today. I think it should be a fascinating discussion. I also appreciate that so many of you have taken the time out of your day to show up to come. I hope it'll be educational and entertaining. I'd like to begin by providing a little bit of historical context for the discussion today. I am the voice of Constitution past, and I want to focus particularly on the question of why do we protect freedom of the press, and what does freedom of the press mean? And the theme of my very brief comments is the constitutional role of the press in a free and democratic society. So I want to go back, carry us all back, if you would, to the 18th century. That's the period between 1700 and 1800. You'll recall that in 1776, we declare independence. 1788, the Constitution is ratified, and in 1791, we have the Bill of Rights. So that puts us, at least locates us in time. The first point I want to stress is the framers' understanding of freedom of the press is not necessarily the same one that we have today. I think we have a much more libertarian understanding in some respects than the framers did. It's an evolutionary development. The 18th century might be considered sort of the teenage or adolescent years in the development of the meaning of freedom of the press. It's a time when the whole idea is undergoing considerable evolution for reasons that I'll try to explain. And there are basically 3 phases. If you had teenage sons and daughters, you might say there are more than 3 phases, and there are more than 3 phases, but we're going to reduce it to the 3 key phases. So, first phase, freedom from prior restraint. We have to actually go back to the 1700s to see this thing develop. And we start off with the English system of licensing, official licensing. You could not publish in England during the 17th century without submitting first your book or your newspaper article to an official governmental censor. This is what Milton objects to so strongly in a very famous piece called the Areopagitica, which was published in 1644. It had an influence, but it wasn't until the end of the 17th century, 1695, that the licensing system in England was officially abandoned. So that was the first phase, and it carries through all the way through the 18th century, both in England and in our country, this understanding, very different from ours. Freedom of the press meant only freedom from prior restraint. If you published something that brought government into disrepute or was considered licentious rather than responsible reporting, you could be subject to subsequent punishment without violating people's understanding of what freedom of the press meant. It meant freedom from prior censorship. That's a very important point, obviously, when we get into the present time, when we talk about cases like the Pentagon Papers case. The court goes all the way back to Milton's polemic in saying if there's any no-no in our First Amendment system, it is prior censorship of the press. Phase 2, pre-revolutionary period in the colonies. During the colonial period, and especially as we move towards separation from England, one of the dominant strands of political rhetoric was this notion that the free press was the bulwark of liberty. It obviously was an essential part of the rhetoric in support of the colonial pamphleteers who were trying to encourage resistance to oppressive British measures, trying to enlist support for the ultimate separation from England. The bulwark of liberty, that's what the press was. You can see it now, it's taking on a different kind of significance. However, you go back and it's very interesting, and you look at that period and you find that the colonial legislative bodies during this period of time were not open to the public. In Massachusetts, if you published the proceedings of the General Court, which was the main legislative body, you could be sent to jail. It was a crime to publish the votes or identify particular voters with how they voted. So this is all true. It's like a teenager in which there's kind of internal conflict. On the one hand, you're marching around saying bulwark of liberty, and on the other hand, people at the same time did not feel it was inconsistent with that to close off the proceedings of government from press investigation. Phase 3. After we separate from England, the colonies which previously had been governed by colonial charters were invited to draft state constitutions. And the state constitutions really are the place where we begin to see emerge yet a third additional dimension of the understanding of freedom of the press. This notion that the press plays an important constitutional role in these emerging, fragile experiments in democratic self-government. First state constitutions follow Declaration of Independence, 1776 to 1780. Virginia first off the line. Then you get Pennsylvania. Then the other states fall in place. These state there was no federal constitutional protection of rights at all, or federal constitutional protection of freedom of the press. So if you wanted to find protection, you had to go to the state constitutions to find those protections. In the state constitutions, for reasons which will become significant very shortly, there were two major sections. One called the Charter of Liberties, or Bill of Rights section. You list the rights and liberties that you want to protect. The other section was called the Frame of Government. And there you provided for how the governor was to be elected, how the legislature was to be elected, the roles and functions of the various institutions of government. Now, the significance of this, I think, will become apparent in just a minute. This is kind of interesting. I looked at the early state constitutions, the very first ones, and out of the 13 original states, 9 had provisions protecting freedom of the press, and only 1 had provision protecting freedom of speech. It's like freedom of speech is the baby brother of this adolescent we got out there. But freedom of the press was the important protection. Freedom of speech, it comes along later on, and we think of it sometimes as being even more important, perhaps, than freedom of the press, but that was not the view that you find reflected in these early state constitutions. I will say that Vermont, which was not a state, protected both freedom of speech and freedom of the press. It's always been a little bit wacky in the protection of individual liberty. Okay. Here's something else that's really important, and in all of these early state constitutions, you find this provision, which to us is like platitude. It's oh hum, yeah, so what, of course. But it wasn't considered that way at this point in the development of constitutional law in the 18th century. And the notion is really an important one. Government officials are trustees and servants of the people. There it is. All power being originally inherent in and consequently derived from the people. Therefore, all officers of government, whether legislative or executive, are their trustees and servants, and at all times accountable to them. Now you begin to say, well, what's the role of the press in a world in which government officials are not rulers and we are their subjects, but they are trustees and servants of the people? That provision, which seems so much like a platitude to us, was part of a fundamental revolution in political thought during the 18th century. If you start and go back and look at the beginning of the 18th century, you have this notion. They're the rulers and they're the people. We are the subjects of the rulers. We do their bidding. By 1776, the time we're talking about, that has been inverted by provisions like this. The people have the power, and government officials are their, quote, trustees and servants. That fundamental revolution is reflected in that provision that I just showed you. So what's the role of the press in such a world? Here's a little puzzle for you. The original Vermont Constitution, 1777, had not 1, but 2 provisions protecting freedom of the press. Why do you need 2? The interesting thing is 1 is included in the Charter of Rights and Liberties. You know, that's one of our rights and liberties. But the other is included in the frame of government section, the section that deals with the organization of constitutional government in the state. The first one says the people have a right of freedom of speech and of writing and publishing their sentiments, therefore freedom of the press ought not to be restrained. The second one, which appeared in the frame of government, says the printing presses shall be free to every person who undertakes to examine the proceedings of the legislature or any part of government. Okay? 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 Okay. And you say, what's this? Yeah, okay. This is the significance of that. It reflects the view that the press in Vermont at this point in time was viewed as having a constitutional role in holding government officials politically accountable. It was considered like an institution of government, much the same way that the legislative branch and the executive branch were considered institutions of government. It was part of the governance of these fragile democratic experiments, and it played an absolutely crucial and constitutional role. It was essential to ensure responsible democratic government. So that's the third phase, right? First, just freedom from prior restraint. Second, bulwark of liberty, but government proceedings and government records not open to the press. Third, now, government is open and the press is responsible for ensuring government accountability. Free to every person who undertakes to examine the proceedings of the legislature or any part of government. We're lucky in Vermont to have, among other things, the Vermont Digger, which engages in very vigorous and very helpful and responsible investigative journalism. We're going to have the editor of the Vermont Digger up here today. But that's the role. That's the role. That is the third phase, and that's the understanding that the framers have by the end of the 18th century. Okay. In a democracy where government officials are the trustees and servants of the people, the press has a constitutional role in ensuring government accountability. So what's the implication for today's conference? The implication is just simply this. How can the press in the modern age perform this important constitutional function? We've got 3 panels. Fast forward, we live in a very different world, don't we, than the world in which the framers lived. The rise of the internet, it's no longer entirely clear what the press is and what the press isn't, but the fundamental role of ensuring governmental accountability is still the central role of the press. For our purposes today, panel 1, we're going to look at some barriers to access to governmental meetings and governmental information. That's sometimes referred to as Foia. It is Freedom of Information Act proceedings. There are analogs at the state level. Second panel, I don't know how much we're going to get into it, but what about the use and misuse of security classifications to prevent access to vital information? And that opens the whole question of the role of leakers, when it's legitimate and when it's not. And then panel 3, what are the other barriers to the press performing this important constitutional role? And part of the problem is the erosive impact on the credibility of the press by this whole emergence of fake news and untrustworthy reporting. So with that, a little bit of historical perspective, let's move to the modern age. Thank you very much.
Galloway from Vermont Digger. We also have Professor Stephen Dycus from Vermont Law School, Victoria Baranetsky, and then Lynn Oberlander. So let's give it up for them.
Thank you all. We'll start this panel with brief introductions made by each person on the panel, and each person on the panel is going to give a 10 to 12 minute brief introduction, and then we'll be taking questions, and we're going to start with Professor Dycus, who will get 12 minutes because he was originally going to be the introductory speaker, so he gets a little more time.
Morning, everybody. Listen to what Thomas Jefferson wrote 200 years ago about the subject of our program. If a nation expects to be ignorant and free, it expects what never was and never will be. Today, we can see the same sentiment expressed in the motto on the front page of the Washington Post every day, it says, "Democracy dies in the darkness." Beyond reporting just what the government wants us to know, or what government insiders may divulge, I mean leakers, which is the subject of the second panel, the media rely on several legal tools to find out what the government is up to and tell us about it. Chief among these is the Freedom of Information Act, FOIA, a 1966 legislative miracle that's completely altered the way the people relate to their government and indeed the way government operates. FOIA substantially codifies the always difficult balance between secrecy and security. It does that by establishing a right, the public and also the media, of access to executive branch agency records. Almost anyone can request almost any agency record for any reason or no reason. Here's a good recent example. Last month, the New York Times reported that EPA Administrator Scott Pruitt had promised farming industry executives that he would not follow the advice of EPA scientists in banning the use on crops of a dangerous pesticide called chlorpyrifos. This story was based on 700 pages of EPA documents that were obtained by the Times through a FOIA request. The Freedom of Information Act has 9 exemptions, records that may be kept secret. Those include classified, properly classified information, personnel records, trade secrets, pre-decisional documents, we'll talk about those, and law enforcement information. If a FOIA document is, if a FOIA request is denied by an agency, then the requester may go to federal district court and ask the court to review the request de novo, and the judge may look at the requested documents in camera to make its own new decision. The burden is on the agency to show that it's entitled to withhold the requested information. In practice, courts have tended to be very deferential, I think more than Congress intended, in upholding agency refusals to disclose information, especially if the information has anything to do with the military or national security. FOIA does not apply to information belonging to Congress or to the courts or to the executive office of the president. For example, last year, the DC Circuit ruled in a case called ACLU against CIA that agencies' copies of the 7,000-page report by the Senate Select Committee on Intelligence, the SISI, on the CIA's torture program were congressional records, not agency records, and therefore not subject to FOIA. Now, highly relevant here are a couple of FOIA analogs open meetings laws, the Government in the Sunshine Act, and the Federal Advisory Committee Act, both federal statutes. Both provide for public access and media access to meetings of government bodies and also to records created by those bodies. Each of those statutes has exemptions similar to those in Foia. A couple of lawsuits are currently underway challenging the Trump administration's creation of advisory groups and task forces as violating the Federal Advisory Committee Act. Also relevant here are laws requiring the preservation of federal records. Chief among those, the Presidential Records Act. Each president's records, official records, must be preserved. At the end of a president's term, all of her records have to be turned over to the National Archives, where they generally are subject then to access through Foia. Nevertheless, those records may, at the direction of the outgoing president, be kept from public access for up to 12 years, and an incumbent president may bar the disclosure of a former president's records unless a court rules otherwise. This is an area that still waits to be worked out. The Obama White House turned over its copy of the Sissy report on the CIA torture program to the National Archives back in January, just so that it won't be lost through the efforts of the current Republican leadership to retrieve all those copies and possibly destroy them. The Presidential Records Act applies to all official business conducted on non-official electronic devices, including Gmail, WhatsApp, those sort of things. Donald Trump appears to have violated the Presidential Records Act by deleting many of his tweets. Also relevant here, the Federal Records Act, which likewise requires preservation of federal agency records, which eventually end up with the National Archives as well. You may be aware that the Trump administration has been busy purging its websites and of any information relating to climate change, among others. If this information is not preserved, then that would represent a violation of the Federal Records Act. Worries that this information will disappear forever have led a number of people to create private archives of those data and make them available to the public, among them our own librarian, Christine Ryan, here at Vermont Law School. Most states, as Peter mentioned, have freedom of information laws that roughly parallel Foia. My fellow panelists will talk about those. I want to talk about two other tools. One, a common law right of access to government information, public right of access to public records. This is an ancient right that applies to not just to the executive, but to all three branches of government. This common law right, not widely known or understood, may be preempted in part by Foia, maybe. As recently as last month, the DC Circuit held that the Dodd-Frank law, which bars disclosure of certain financial records, does not preempt the common law right of access to court records. This is the MetLife case. On the other hand, the DC Circuit held in March of this year that the common law right does not cover access to court records that include videotapes of the force feeding of Guantanamo prisoners that were properly classified. The other tool I want to mention here is a constitutional right of access. First described as a right of the media to gain access to criminal trials. That right has been limited by the Supreme Court to access where there is a tradition of accessibility. There's a good deal of disagreement about what that means, where public access plays a significant positive role in the understanding of people about the way government operates, and where it's not essential to close off access to the public. This is the press enterprise case. A number of courts have found that this constitutional right applies to civil trials as well as criminal, and also to agency records. In 2002, the Third Circuit held that this First Amendment right did not apply to deportation hearings. At the same time, and on identical facts, the Sixth Circuit held that, that the press is entitled to attend immigration or deportation hearings.
Excuse me, Professor.
Yep.
I'm afraid your time is up.
All right. Good. I'm at the end of my remarks, and I'll be glad to answer questions.
I'm glad the timing was good. Thank you. We will next hear from Victoria from the Reporters Committee on the Free Press.
Thanks. And I actually have recently just begun working at the Center for Investigative Reporting, which is an exciting new development. So I think that what I have to contribute here today is that I have the unique perspective of being in a generation of young media law attorneys that have grown up in the age of Foia being the bread and butter for journalists. So the New York Times, which used to be my former employer, used to have a docket filled with libel cases. And today, the New York Times is the #1 litigator of Foia cases, being a majority of its docket. Now since the Gawker case, the tides might be changing back for probably for the worse. But regardless, Foia has become a main staple for a media law attorney. And so growing up with Foia, I want to underscore a particular tension that's been there since the beginning, which is we want transparency, but not too much. And that's been there since the beginning. So as Professor just mentioned, Foia was passed in 1966 in response to Cold War concerns about corruption and, the Red Scare and secrecy. So President Johnson signed the bill into passage, but there was a lot of pushback from the agencies, even at that time, even at the time of passage, immense pushback. Once again, leading up to Watergate, there's a lot of corruption, a lot of corrosion, and then we have amendments that come again to Foia to strengthen the bill. And so then, once again, we have the Obama administration in more recent history that promised one of the most transparent governments around. It reversed the Bush-era guidelines, which stated that they could withhold unless there was a sound legal basis, and then reversed that to a presumption of disclosure, so just presuming that things would be open and let out. You have a backlog that's developed during the Obama administration by 2014 that had gone from 77,000 documents all the way to 77,000 requests to 160,000 requests, right? So that's more than double. At that time, Bloomberg did a news test. They filed with a bunch of agencies around the country. Only 8 out of 57 responded within the 20-day time. Under FOIA, you have 20 days, the agency has 20 days to respond. Only 8 complied with that requirement under the statute. And then you had this problem of very few FOIA employees being around to actually answer the growing demand of FOIA requests. So around 2015, you have a lot of kerfuffle, and you can really hear Congress beginning to lambast the Obama administration for failing on their promises. And you have a full House hearing where people are requested to come and speak and testify. My former boss, David McCraw, spoke there, the attorney at the New York Times. So did another heavy reporter that is now at BuzzFeed, and a few other people to answer questions to Congress. And it actually had approval in both houses to amend FOIA to make it stronger. But there was still, once again, just like in the Johnson era, pushback from agencies. And so there were actually a bunch of agencies that had reached out, officially or not officially, to members of Congress to discuss these various new legislations and amendments that were going to be made to strengthen the bill. And so, at that time, I was working on a pro bono basis for this organization called the Freedom of the Press Foundation. And we filed a lawsuit to ask the agencies to disclose what contacts they had made to members of Congress about these bills. During that time, there was luckily a lot of pushback, and after the congressional hearings, the emails were disclosed, and Congress did end up passing more recent amendments. So there have been changes to make FOIA stronger. Some of those clauses have not been tried out. They will be probably eventually in the next few years, and we'll be seeing whether those amendments will, prove the pudding to the butter or something like that, right? But as we've seen since the new administration has taken office, that old habits die hard. In June, many publications noted that the Trump administration has denied releasing its White House memorandum, its visitor logs. There have been scrubbing of websites, and they've not even been willing to admit whether Donald Trump is playing golf on certain resorts or not. So this is just sort of a backdrop that I just wanted to set the tone of where things have lied in the past few years and sort of what the conversation is. And now I just sort of want to, so it's a helicopter approach, and now I want to sort of zone in on 3 specific issues that I've become more concerned with within the FOIA legislation. So the first is a GLOMAR response. And so under Exemption 1, which was noted, there is a specific response that an agency can give, and it's been dubbed the GLOMAR response, which is actually named after a ship that sank to the bottom of the ocean in the 70s. And the response an agency gave in that case about the ship was that they could neither confirm nor deny that the documents even existed. So forget about getting the documents in the first place. The agency didn't even want to say whether there were any such documents, which is sort of an outstanding kind of response, right? Interestingly, I worked on a case while I was at the Times a fellow, where we had a reporter whose father was actually a double agent for the United States during the Cuban Missile Crisis, and had asked for documents from the CIA about his father. Lo and behold, the CIA responds, "We can neither confirm nor deny that these documents exist." Well, we had a wonderful student from the Yale Clinic who, not as good as the Vermont Clinic, but at the Yale Clinic, who went to assiduously went to the CIA's website and found documents with Mr. Flores' name in them. And so when we filed the lawsuit, we brought this to the court's attention. And the case ended up resolving with a good ruling on GLOMAR that it is not, it cannot be used in all circumstances. So that's a very nice case. It exists. However, GLOMAR is a pervasive problem. We can talk about it more later, but interestingly, it's something that's been created in federal law, federal Foia, right? But it's been brought into state courts under the state sunshine laws, or the state FOI laws. And so that's one of the major problems. Another major problem is that in addition to this rise of it becoming a mainstay for the media, it's also become a big tool for corporations. So a lot of corporations are now using FOIA and flooding agencies with requests in order to gain important data about what economic advantages they might be able to get, what are the government perspectives. And that's also, so that's changed the tenor and sort of the taste of FOIA. And recently, while I was working at the Reporters Committee, we had a case there where a journalist from courts filed a request for documents and was given a response that he had to pay for the documents, which is also an outlandish position for an agency to take, just like GLOMAR. Under FOIA, there are supposed to be minimal fees, but not for the price. You're not supposed to actually pay for the information itself. You could pay for processing, for copying, but with limited exceptions. And moreover, the media is actually supposed to have a waiver from those costs. So that's a rising trend that I'd like to note, and is something that's interesting and as in a development. And then the last one that I'd like to mention is the issue of search. So under the FOIA statute, an agency has a requirement to do a search, a reasonable search of their documents. This has sadly diminished in what is actually required of an agency. Courts in all circuits across the country have only maintained that agencies must only do a bare minimum search. And one great case where this was elevated to the forefront was another case I worked on at the Freedom of the Press Foundation, in which they filed for the FBI for their rules on how the FBI did searches of journalists according to national security letters, which is a procedure. A specific procedure used by the FBI. In any event, they wanted these documents, they wanted to see them, and the FBI said, well, we've done a really thorough search, and we've found absolutely nothing, and there's nothing there. And it turned out that The Intercept leaked while we had made this litigation. The Intercept leaked these documents. They had somehow miraculously found them, even though the FBI couldn't put their finger on whether they even had the documents or not. Sadly, that case wasn't appealed for a variety of reasons, but I believe that there's need for more cases challenging the agency's requirement to search, which may be challenging given the greater number of FOIAs that are being filed around the country. And I know the Reporters Committee is currently conducting one of those cases right now. And I think that's a very important line of work. Anyway, I'm thrilled to be here, and thank you.
Thank you very much. Next, we'll have Lynn. Lynn from the Gizmodo Media Group, please.
So, hi, good morning, everyone. I have had the great pleasure of working for a number of media organizations over, my 20 years as a media lawyer, and in all of them, and I'm going to, I was at NBC, I was at The New Yorker, I was at Forbes, I was at The Intercept during this interlude that we've just heard about, and I'm now at Gizmodo for the last few months. So, and all of the places I've worked have been involved in FOIA litigation or public access or state record stuff. And I am here, I think, to provide, I don't think this is why I was invited, but I'm going to provide a little bit of a damper on it. I am really critical of it. It is a arduous, expensive, time-consuming, and a fairly miserable way of getting information. And I'm really curious to see what, Anne, you're going to say, because I know, because I do think that there are, I mean, and I'll talk about it, I think there are some real benefits to state open records law and FOIL law, and there's a lot of room there, and many states are better than the federal government, but I don't want to put too much pressure. I mean, it's great that we have the FOIA laws and the open government laws, and they do set a boundary, but they are really, it's not, as a journalist, they're not great ways to get information in terms of actually getting the information for your reporting. It takes, so what ends up happening, and Victoria mentioned a lot of this, is a journalist will do a story and they may send out if they're smart, they'll send out a FOIA request. They won't get a response, or they will get a response, which is a denial. Then they have to either write an appeal letter, which is full of sort of legal traps, in terms of if you don't know exactly how to do it, or they have to go to their in-house lawyer like me, or rarely an outside lawyer who they can afford to pay to figure out how to write this appeal letter. Then you send the appeal letter off. Then you're denied again. I mean, sometimes you get something, but there's almost always a denial. And then you have to decide whether or not you are going to sue to get these documents that have been denied for you. And then you have to go through all the steps, like, do you have a good case? Are you going to have it? Can you find a counsel to file this litigation? Corporately, is there support for filing litigation? How many other cases do you have? Where are you going to spend your time? And sometimes when you go to court, sometimes the government immediately folds because they have no real reason to withhold it. But sometimes, hey, you know what, the U.S. attorney or the AUSA on the case thinks, hey, this is, kind of interesting, or this is what I get paid for, so they're going to litigate it. And it is, so for certain types of stories, clearly for some of the national security reporting, for the White House logs, there are reasons to go through this process and to litigate. And 3 years later, you may get something, and you can then write a story about it if you have those resources, or more. Or you may not get something. And if you're writing a book on it, you may be able to use that information in a book, but it is not a way for regular journalists to get material for their sort of daily reporting. And not even for daily reporting. Even if you're doing a months-long investigation, you're unlikely to get the information. And so what you have is you have a lot of orphaned requests out there where the reporter goes off to something else because, hey, life is only so short. And then you don't even institutionally have any kind of, then the only one who's really pushing this FOIA request is the lawyer, who also has other things to do. So it is I'm a little down on it, on that. And where it has worked, and I've worked with a lot of reporters for whom it has worked, are there kind of 2 or 3 exceptions. One is that if everybody, including the government, and this could be state or federal, they want to give it to you. They want the information, and because they know it's in the public interest, and they want it out there, and they just need that email request so they can send it to you. And sometimes that happens. A lot of times, actually, that does happen. And so you just send the request, they send you the stuff, great, then you can report it. The other place it happens, and this comes to Victoria's question about search, is when the journalist has done enough pre-work about it. And so when I was at the New Yorker, I worked with a lot of great journalists, actually, but with Rafi Kachadorian, who is a incredible, thorough, he was a former fact checker, maybe this is it, reporter. And before he would send a FOIA request out, he would interview everybody around to figure out where the documents were and what he was looking for. And so he would send the most specific requests. And then sometimes you'd get a response back that would say, well, we've searched and we can't find them. And he would get on the phone, and this actually happened. And he'd say, no, they're in the closet in so-and-so's office on the 3rd shelf. And then we'd get the documents. But it isn't, it's, on the other hand, and just to take the government's perspective, they are understaffed. A lot of these requests, a lot of them are blunderbuss requests. Like, give me every single document about whatever, about, PERC or some chemical everywhere, including all emails and all communications that, for the last 15 years. They really are fishing expeditions, and this is to criticize, my colleagues as journalists. And of course, that's not going to work. So, I mean, we do use FOIA. We're litigating a couple of open records and FOIA cases right now at Gizmodo, and I think it's important. The other thing I did talk about cost. The cost is expensive. So, if you're successful, you can get fees. Sometimes. I mean, usually you're supposed to be able to get fees, but if you spent a lot of time and a lot of money on it, you're probably not going to get all of your fees back anyway. And it is, so there are a few places that have now, especially in this administration, but they were, things were going on before, have made a little bit of a sort of business model of suing on behalf of journalists and hoping to get fees. And if they do, they can file a lot of suits, and eventually they will make a living, and that's great. But there aren't really enough people doing that work. And for news organizations who are already strapped, it is 3 minutes. All right. It's just it's a difficult decision to decide where to spend those dollars and those resources. So I think those are my comments on it right now.
Thank you very much. That was very helpful. Professor Dycus is going to respond for a minute and a half, and then I'm going to make a few remarks.
Some years ago, I was involved in a FOIA case, request to FEMA to disclose planning for continuity of government following a nuclear war. The initial response to the request was that FEMA had 1 million documents responsive to the request, and it would cost us $150,000 to process it. This was a bald-faced lie, evidence that agencies use fees as a weapon to resist requests. When we filed suit, miraculously, a lot of documents came forth, and with each succeeding action in the district court, more documents dribbled out. Eventually, our case was won in discovery, when, just following up on Lynn's example, the lead lawyer in our case asked, first of all, if the FEMA representative even knew what continuity of government meant. He said no. And second, asked whether he had looked here and looked there, and the FEMA representative said, well, no. And that was that, and we got a nice fee in the process. So I'm interested in knowing about, especially about the experience with agency bad faith and how that has played out in the award of attorney's fees and also costs.
Do you want to respond?
Well, I mean, it is, I think if you can show bad faith, you can get fees. But that to do that, you're pretty far down the line, and you're committed to suing, and you have somebody who's supporting you, and you're somebody who's doing your legal work up until that point. And so it is a sort of a marker, out here. It's a control, but it doesn't, in the end, I think, really affect, the day-to-day too much. And there's still a lot of room for bad faith.
I agree with Lynn. I'm pretty skeptical or cynical about how the whole system works, because at Digger, we make it our business to place public records requests all the time, because that's just part of our work. We have beat reporters who focus on healthcare or education or criminal justice and so on. And yesterday I was on the phone with 3 of our reporters discussing public records requests and how we were going to make them. And one of them is in this case that you may have heard about. There were 5 Vermont State Police officers who shot at a man with a BB gun in East Poultney. We asked for the records immediately afterward, and we were our request was denied by both the Vermont State Police and the Vermont Attorney General's office, and so I contacted the ACLU to see if they would be willing to bring a case because, you know, as my reporter Alan Keyes put it, you know, it's been 2 weeks since the shooting happened, and they should have interviewed everybody by now. So, you know, it's not like releasing the body cam video is going to make a big difference at this point in terms of the investigation. And I think that, you know, embarrassment's never a good excuse. And that, I think, is really the excuse that most people use ultimately. I mean, they're not supposed to under the law. It's actually written into the Public Records Act that embarrassment's not a reason to withhold a record. But in Vermont, it happens to be pretty common. We seem to be embarrassed a lot around here. I'm not quite sure why. But, you know, to Professor Dycus's point, you know, that $150,000 sounds like a real bargain. I asked for the EB-5 records involved in the J-Peak fraud, and they wanted $200,000 for 50,000 records. So, you know, do the math. I think that million records for 150 is pretty good. And you know, the reason that we I did a sweep. I don't usually do a sweep, Lynn, like your colleague at the New Yorker. I think it's very important as journalists to respect the time of government officials who are working very hard just to get their jobs done. And, you know, unfortunately in Vermont, we have these people who are designated public records custodians, but they have other work they have to do. And it is very important to us to be as specific as we possibly can. And in the case of this EB-5 question, I did a sweep because I found out the Shumlin administration had planned to redact all the records before they put them in the state archive, which is just an outrage. At any rate, we prevented that from happening because we got word of it, and we had a serious conversation with the Secretary of State about it and the state archivist, and they put the screws to the Shumlin administration. And in theory, I don't know for sure, but in theory, they have not redacted the records that are in the state archive. You know, it is a fight every day for us to get records, and it's absolutely exhausting. You know, we were in a fight with the Agency of Education yesterday over special education records, because you may have known that the state was not enforcing the special education laws properly for like a 5-year period, and we wanted communication between people in the Agency of Education about why it took so long, basically, for them to comply with the law. And they're denying those records. They're claiming executive privilege and attorney-client privilege. Attorney-client privilege is invoked all the time, and I think it's being abused. And I think that people are just, you know, when we do get records, they're heavily redacted. Whole pages are missing. We worked for 6 months to get records on, you know, that town clerk up in Coventry that allegedly stole $1.4 million, Cynthia Diaz. Well, you know, the AG did an investigation of her and concluded the investigation in 2011, and we had a heck of a time getting those records. It took us 6 months, and like Lynn was saying, it's more than just placing the records request. You're trying to negotiate with people at the AG's office to get this information, and then they drag it out. There's a meeting. We're told that there are 3 boxes of files, and they wanted to charge us to actually go through those boxes. I said, I don't think so. The fact that you're disorganized is not my problem. You know, I mean, seriously. I mean, our request was specific. We knew exactly what we were asking for because we had sources who told us what we should be asking for, and we used that information to ask for it. So anyway, I think it's a disaster in Vermont, and I think that we need to change the Public Records Act, but there's no appetite for that in the legislature. And at this point, I think the solution might be, I don't think any state's done this, so it's a little bit radical, but I think we need a court administrator who reviews records requests. And I don't mean an ombudsman, I don't mean a quasi-judicial person, I mean someone designated in the courts who can just review records in camera and tell us whether the fox who's guarding the chicken coop is being honest. And that's really all I have to say.
Do you guys? I mean, how do you get? I'm curious. Do you have a staff lawyer? Do you, or in each of these denials, do you have to go out and find legal assistance? Do you work with the legal clinic? How do you?
I'm proud to say that Tim Cornell is here. Could everybody? Tim, could you stand up? Could everyone give Tim Cornell a round of applause? Tim Cornell is my favorite lawyer, and I'm his favorite journalist, so we have a mutual admiration society going on here. But Tim has represented us, is it okay if I say this? Has represented us pro bono since 2011. And he's been there at every turn. If we have a story that we're worried about, we think we're going to get sued over, he reads it. And he has gone to court over records for us repeatedly, and it's because of him that we've been able to really muster the courage to go after this stuff. But I can't ask him to do this all the time, so sometimes I get the ACLU involved because I could probably employ Tim full-time at this point with pro bono work, which wouldn't, put food on the table. So it's a little tricky, but yeah, no, I wish that, we could sue at every turn, but, we can't. And I want to work with people. I feel like our requests are reasonable and that people are jerking us around and it's not fair. It's not fair to us, but it's really not fair to the public, okay? Because people should know what the state did, how the state was, I believe, complicit in allowing that fraud at JPEAK to occur. And we won't know because we've got this really broad exemption in the law. Relevant litigation, is an exemption. And we fought that and we couldn't win it. And I just think it's a crying shame. And the legislature doesn't care enough to change the statute. So we're in a position where the public has a right to know, and that right is not being satisfied. So.
Is there a common law right in Vermont that might give you access to those records in litigation?
I don't know. You tell me. I'm not a lawyer.
I'm also
Yeah.
Well, here comes the mic.
Okay, so I can't remember how it's worded, but in the Vermont Constitution, there is language. I just wrote about it in that Supreme Court brief. There's language that puts all documents primarily belong to the citizens, and so it's up to the government to provide reasons why it must withhold. So that goes back to 1787, and then the Freedom of Information Act kind of is on top of that. But before that came into being, there was there were a series of cases that gave a common law right to freedom of information.
And do you know whether the common law right was preempted or supplanted by the FOIL?
There was a case in the late 70s, early 80s that said it was not preempted.
There you go.
cool.
Yeah. Well, generally, I don't think the common law rights of access are preempted by statute.
So how would we pursue that? Tim?
Well, that case, as I recall, it unfortunately it didn't make citizens' freedom of access to information any broader than what the Freedom of Information Act provides. I mean, it says yes, so it belongs to the citizens, but there are exceptions to it. It comes out the same way. But the fact is, there is a common law right to it.
If there ever, if it ever goes to court, of course, the JPEAK fraud and those documents are relied upon by any of the, if they're attached or they're exhibits or they're relied upon by the judge, then you can get them.
I know, I'm afraid I'll be dead before that happens.
Yeah.
I just want to throw in some optimism here.
Oh, good.
my young naive eyes. I think that what's been said is absolutely correct, that it's not a tool for a short-term basis, and that sadly, as there are more and more denials, the only way to get responses under FOIA are by filing, which is a sad truth. If you do have those resources, though, I think you can find very interesting things, particularly if it is not the thought-smoking gun. Right, there's a lot of stories that have come out of FOIA requests that have been data compiled. I remember a Times reporter ended up requesting some documents about pets in New York City. And then from that, she was able to get a very interesting economic breakdown of a certain building, right? I remember another reporter filed for correspondences with the United States Post Office from every single agency, and then was able to detail a surveillance program that the United States Postal Service conducts. And so there's a lot of interesting compiling FOIA requests that can create good stories, but it's absolutely true that they require dogged reporting and often a very active in-house counsel team that's committed to that. So that's certainly a downfall. What I'm curious hearing in response back about is how this relates actually to the later panel about leaks. You know, if we decide that FOIA is not broken, or if it is broken, then our leaks are only option. Should there be FOIA? So should there be a stronger FOIA as a justification that perhaps leaks shouldn't be the method through which this is happening? I'm curious also, just from a reporting context, what your experience is and how your reporting changes from the types of documents you see in a leaks perspective versus a FOIA perspective. I can imagine what I've said before, which is sort of these longer term pieces might bode well for FOIA, but are there other discrepancies that are interesting to point out or that you've seen, or just the relationship between the two, if there is one?
Part of the answer comes from a Professor David Posen, who described this phenomenon as involving deep secrets, or to channel former Defense Secretary Donald Rumsfeld, what we're dealing with in leaks more often than not is unknown unknowns.
Yeah, I think it's a really interesting question. And I do want to say that I am glad that we have these laws on the books. Very much, very glad. I mean, I think in the implementation is really tricky. But if we didn't have the laws on the books, we'd be a lot worse. So let me just say that. And I do think that there for some of the I don't know about those time stories you talked about, but the time story that I'm thinking of was probably like a decade ago. Times did a big series on disability fraud involving former railroad employees in Long Island specifically, and where they were all being retired at disability, for disability. And of course, the next day they were all, well, when you look, they were all being photographed playing golf with no disability at all. And so, and I am sure, I don't know this for a fact, so when I say I'm sure, hyperbolically, but I am sure that that was the result of a leak, and then a tip, a tip, not a leak, a tip, and then the Times reporters knew to go after those particular set of disability records, and so then they could use the law to get the material once they had the tip, and that is that's great, right? Like then you actually aren't. Then you're not like, throwing this net out there and saying, oh, well, maybe there's some data here that might be useful. Then it's a much more focused, let's look at the data that should belong to the public, uncover fraud, and use it. And then that's that's kind of a great use.
I'd be remiss not to say that many state officials are very good about responding to records requests, and the Department of Health is right up there. I have great respect for the folks and who's the guy who's the custodian there. He always responds to our vital records requests very quickly. We've had good responses from the Department of Taxes and others. So it's not everybody, but it seems that when there's a deep, dark secret that people want to keep, that's when you run into trouble. The other thing that happens is that sometimes we'll get a dump. You might end up with, like in the case of the PFOA contamination down in Bennington County, the hay was dumped on our heads and we had to find all the needles, and that was fun, but that takes a lot of time also. So, but thank God for the Public Records Act and for FOIA, because we wouldn't be anywhere without it. And the tipsters are helpful, but then you have to verify whether the records they are giving you are legit, and sometimes you actually have to place the same record, with the agency to make sure that you're really looking at what you're looking at. And but yeah, Walt Bogdanovich did that series on the Long Island Railroad. That was a great series, and I'm sure he had a tipster too.
I think you're right. Like EPA documents, also on PFOA, and we did some work on that in The Intercept. The EPAs, the state EPAs, end up being usually, pretty helpful. It's not that, and turning that stuff right over. So it isn't the case that everybody is always saying no.
That's right.
Yeah.
Yeah, I think the real bad actors usually here, like DHS and FBI and CIA. I think DHS has a response time average of 60 days when the response time is supposed to be 20 days. And that's their average response time, so it's triple the amount.
Yes, we have a question.
So FOIA, the FOIA model is responsive in nature. Someone outside of the government makes a hopefully specific request, and then government officials provide the information. Do you have much experience with, or have you given much thought to that other aspect of FOIA that actually affirmatively obligates government agencies to put certain information out there without request? And have you given any thought to whether that's an area where we could stand some expansion of the obligation on government agencies to act proactively in disclosing information without waiting for specific requests?
So I think actually this is what David Posen somewhat suggests in his response to the deep secret state, or whatever the lovely alliteration there is. He says that we should be pushing agencies to publish more documents with their data analysis of internal statistics. And then the pushback of that is, well, there will always then be withholding, regardless even from that. But maybe in the same way that Lynn just defended FOIA, like better for it to be there than not, perhaps it's better for there to be required documentation. I'll say that from a meta perspective, OIP under DOJ publishes every year this type of report, right? So they publish a report every year, and it breaks down FOIA, and it says these agencies got this many requests, they responded this many times, they gave these kinds of denials with these kinds of reasons for justification and exemptions. And they're incredibly helpful. They're incredibly helpful for academics. They're incredibly helpful for litigators. They're incredibly helpful just as a response to know for journalists to say, you know what, maybe see if the EPA has that document instead of DHS. Or, that's rarely the case, but it would be great if it was all the time. But that could be a circumstance, right? So I think it's a great idea. I don't know how often it's been suggested. Those are some instances where it has been, and I think it's a good idea, and it should be pushed for more.
I think it's great. And there are some agencies, right, who do put up a lot of information, and maybe you're right, more regular, or it would be terrific. The one thing that I thought of is that, just that this administration came in and took down all of that government information, which to me, it was just kind of crazy, but they did. It was public one day and disappeared the next day, and or the next week. So that's also, I don't know where that is here or there, but it is, it's kind of disturbing. Yeah. There's another question there.
Okay.
I worked in e-discovery in a big corporation for 10 years, so I want to raise the ugly T word about technology in the law, because I think that's a big part of the problem in responding. The government's technology is archaic. They do not have good search engines, and they have no incentive to invest in good search engines, because then they remove a big part of their excuse. So we talk about staffing, but it doesn't matter how many people you throw at it. When we're still talking about the third shelf in a closet or 3 boxes of documents, we are not talking about the data in the government, right? I left the industry 5 years ago. At that time, they were saying 93% of the records that are used in this country are never printed. So if you're only interested in 7%, then we talk about paper, right? But that's not where the data is. So, and even when they talk about the things that were taken down, nothing was taken down quickly. What they did was renamed the White House, the old White House website to obamawhitehouse.gov, and the new one was whitehouse.gov, and they started populating it. But it's like taking, for those of you who are librarians, taking the index card out of an old card catalog. All the books are still on the shelf. You just lost the card, right? And until you burn that card and then go find the book and every copy of the book and every person's notes from the book, that data is still there. It's about finding the data. So the only systems, the legal profession and academia, unfortunately, aren't too far behind the government in worst systems and worst search tools. Fortune 1000 companies have amazing search tools, and they couldn't run their businesses without them. So I'm just putting in a plug for thinking about technology and how to beat the government at its own game. We need more technologists working directly with lawyers, writing requests that are very specific that say, we need it in this format. You tell them what format, you tell them the name of the database. There are ways to refine this so that you can actually point them to the right systems and get the data in a way that then can be searched. But somebody has to invest. And if the government's not going to invest, the legal profession may find it very helpful to invest, because we can still get to the data that way. So just a plug, I know a lot of lawyers say, don't talk to me about technology. I went to law school because I didn't want to do math, and technology means math. But if you're going to be a lawyer in the 21st century, you're going to have to do a little bit of technology or understand it, or have people working really closely with you. And it's a more than a full-time job. You can't keep up with the technology and keep up with the law. You need a team of people that work together to do that effectively. So.
Amen. Right on.
I'm so glad you raised that. I think that it's interesting because I think it cuts both ways. So in addition to the government having, ancient search capabilities and technological resources, the corporate side has ballooned with these abilities. And so there have been a lot of requesters that have just been creating, for example, just bots for FOIA requests. One of my favorite is Parker Higgins, who's an artist, and recently created a bot so that every time there's a New York Times obituary, it plugs into this algorithm that sends off a FOIA request about this person. And so he's just compiling that data. And this creates a real problem because it contributes to the backlog. Should that be prioritized? Should reporters' requests be prioritized? So that adds to the technology part. And I also just want to underscore that the search element, I think that would be just brilliant. I know that there's a researcher at MIT who's also brought up the government's capabilities in search a lot in his petitions, and that should totally be challenged, and I hope to do that.
So I know Professor Taub has a question, but Victoria raises sort of another question for those of you who aren't steeped in FOIA and FOIL law, which is that there is a whole nother set of FOIL law about whether you deserve expedited processing or not. And frankly, if you don't get expedited so you can get expedited processing if you're talking about something, you represent the press, it's something of current and vital public interest. Maybe it's going to show, you think, fraud of the government. There's a whole set of tests, and then you have to make affirmations around each of those. But that's a whole nother area that you can get sidetracked to if the government says, you know what, this is an old story, you don't get expedited processing. You may then have to sue just as to see whether you are, and there's a whole body of law there as to whether you should qualify for expedited processing, even before you get to whether your response is, whether you're going to get a response or a GLOMAR response or any other kind of response. So it adds to the craziness.
Totally.
Hi, first I just want to thank Professor Teachout on this whole panel. You have made us feel so much smarter so quickly. And this question is probably for both Professor Dycus and Ann Galloway. In your introduction, Steve, you mentioned one of the exemptions or exceptions to FOIA had to do with ongoing matters. And then you raised this issue in connection with the JPEG scandal. Agencies sometimes don't close files. Can you help out on, and maybe all of you, where is that line, and why wouldn't it be to an agency's benefit if they wanted to not be embarrassed to just kind of keep things open perpetually?
Yeah, I think you're referring to Exemption 5 in FOIA, the pre-decisional exemption, which roughly parallels the executive privilege in discovery, which says that, in effect, that agencies should not have to disclose data about ongoing discussions of policy that are not yet settled. The idea being to enable free and open debate about contentious issues, which, if made public, would stifle or chill debate, and that would not be in the public interest. So the big issue that's arisen here is, when does this discussion mature into a settled policy? When does it stop being pre-decisional and become settled agency policy, which is, in fact, accessible to the public through FOIA? And I don't know the answer to that question.
I don't know the answer either. I wish I did. I mean, it would make sense that when an administration leaves, that, the Shumlin administration, like the Douglas administration and the Dean administration before that, has a period of time in which they don't have to release documents under executive privilege rules, that they actually negotiate with the Secretary of State's office, and traditionally it is basically the length of time they were in office. So, Howard Dean got 10 years, Douglas and Shumlin each get 6 years, and in theory, everything is released after that period. So in terms of the executive branch, that's a firm end date. With agencies, though, that's where I get confused, because, you have a whole new set of players in the Agency of Commerce and Community Development, for example, and they no longer, many of those people, there are a few hangers-on from the former administration, but most of that staff doesn't have anything to do with the decisions that were made, 3, 4, 5 years ago. So it is an interesting question, and I don't know how we get at that, actually.
I want to add, there's another question. I just want to add one thing, which is, again, I'm feeling bad about how negative I was. There has been a flood of money since the election into groups that are supportive of both of press rights and information rights. And so there actually is, the Reporters Committee, had a huge amount of money come in terms of donations and foundation support. The ACLU, we all know, raised $18 million overnight or what have you. I mean, it was, I mean, there is a lot of money now, and I actually think in some ways people are looking to figure out how to spend it in a wise and way. But my old The Intercept, First Look Media, has a fund to help journalists with both offensive and defensive press freedom issues, and one of them is absolutely public record, so act type things. So there are places available now to get some financial support for litigation, and I'd certainly, if anyone here is involved in any of that, I'd encourage you to, to look for it, because it's there, and I actually think it's kind of they're easier dollars to get than they used to be. So
That's great to hear. Yes.
I've got one for you, and I'll second Professor Taub's compliments to the panel. It's been very interesting. A lot of our audience are law students, and we're all in favor of as much information being available as possible. But many of the students will become attorneys in government agencies, and they'll be faced with exactly these questions. And I'm wondering if you might talk a little bit for them about the proper use of the attorney-client privilege, because it's often overused, and some of your comments have suggested that already. In which cases, when you're looking at getting records, do you think this is a fair and appropriate use of the attorney-client privilege, and help our students understand how they should be properly using that privilege when they're representing state agencies?
Well, as a non-lawyer, I'll say that I think it's outrageous when records are passed back and forth within an agency with the attorney CC'd. That's just not fair, and that's just not right. And I don't think they should be able to block records requests in which that's the case. So that's a sort of simplistic response. I know it gets way more complicated than that. And to me, the attorney-client privilege should only be invoked when there's a direct interaction between state officials and attorneys about a matter that actually is relevant to a legal issue. It shouldn't be to block records requests, and I think that's how it's being used.
I had an intern actually who was a FOIA, had been, before he came to the Wikimedia Foundation, had worked at a government agency denying FOIAs, which was fun because I got to rail him over the coals and get all the insight. But so as for the attorney-client privilege, one of the key things that I tell journalists is always look if there was someone CC'd, like a contractor or consultant, right? So attorney-client privileges are often easily broken. And so the first thing I would say is be very careful as to who's in the room and who you're talking to. Make sure it actually is confidential. And that's a very easy way to break it on an email by just randomly adding an additional person. So taking that responsibility very seriously. And then as for FOIA in particular, the attorney-client privilege, it's not total. It does only cover those matters that deal with the legal issue, and there are other things that can be skirted around it. So also just being very careful about what you put in writing and how you sort of thinking that every email, I was told this when I went to journalism school, just think every email you write, and would you want your mom to see it, your partner, and your best friend, right? And that's probably a good rule for a lawyer too.
A couple of my panelists have alluded to the fact that FOIA may provide an opportunity for a government insider to make public information that otherwise wouldn't come to light. So there's an opportunity for a lawyer who has to search her soul to decide where the attorney-client privilege comes in. Also relevant here, and it's come up in the second panel, is leakers. We'll talk about why leakers leak, but in response to your question, Tom, a leak provides an opportunity for an insider, for whatever reason they have, to bring information to light, but to do it anonymously without risking the punishment that would come with violating the canons of professional responsibility.
We have two more questions, one over here and one over here.
Hey, I have a question about this variation between the agencies. I did a tiny bit of FOIA work at my internship this summer, and I learned pretty quickly that some agencies are way better than others, and some individual staff members at agencies are better than others. So that suggests to me that it's not impossible for agencies to comply with FOIA, it's the law itself isn't a structural barrier to giving out this information. So how do we increase the consistency of compliance across agencies, given that maybe it's not the law's fault? Do you have any suggestions for that?
Well, I mean, I have two sort of comments on that. One is that a lot of the public information officers at various agencies, I mean, I don't know in Vermont, but generally are former journalists and former reporters, and they actually do usually want to help. Mm-hmm. So, you know, if you can figure out who in the agency has that background, they may be the person to call rather than the other clerk. And the other thing is that just generally education on FOIA, on open records, on open courts, on open meetings is really useful just across the board. There are a lot of folks who are in government and who don't even know that there's this public right to show up, or school board meetings, that there is a tendency towards secrecy, and they just don't know that the open meetings rules require that they be open or that they exist. So. My suggestions.
I mean, in my experience, it's the agencies that have been schooled in some way by the Vermont Attorney General's office that are the worst. And, aren't they working for us? Just saying. I mean, Peter made that clear. Accountable at all times. I think that needs to be our mantra. Because you know what? If we're not accountable, people stop believing in government. They don't know what's happening. They get cynical about it. We have to be transparent about what we're doing in government if we want people to support the whole notion of democracy.
Hello. I'm curious about to what extent does freedom of information extend to organizations and others that are funded with government money?
So it just depends, actually. So there's case law on this in terms of whether an outside actor, is working with the agency sufficiently to qualify as an agency. So there's similar case law, actually, in cases where Congress, for example, has even had work done with agencies. And then there's a question of, well, does that fall under the executive branch or does that fall under the congressional branch, right? And your question is, well, does this fall under the agency branch or does this fall into a private realm? And so it essentially comes down to a fact analysis in both of those circumstances, and just considering how intertwined they were, and what the supervision was, what the agreement was between the agency and the organization. Were they acting as a consultant? Were they acting? So it's a fact analysis, essentially.
And there is also really some disturbing case law coming out of this. I mean, especially when you look at like higher education around the country, where there's a lot of money and there's a lot of public institutions. I'm not even talking about the private institutions, but the public institutions, which are theoretically, public, and you should get all that information. They're moving a lot of their sports spending into private groups and arguing that you can't get that material because it's now in a private, some sort of private organization that is, distinct from the public university. And they've had some success. I mean, it still is a fact-determinative issue, but it's also going to depend on who the judge is, and that poor child, or why should we know that the car dealership gave this much money? The law is not great.
Yeah, one example is actually Berkeley. There's a library called the Bancroft Library. And when I was at the Reporters Committee, the Bancroft Library was trying to say that documents that it had in its own archive, a library was trying to say that they were in private hands, and so therefore they could not be requested under the Freedom of Information Act. And luckily, after some back and forth with an attorney that was quite extensive, they were persuaded that perhaps that wasn't their position, but that took some counseling.
We have time for one more question right here, and then we'll break.
I'll try to keep this brief. My name is Ivan Slobod. In my former life, I used to be the legal affairs reporter at the Canadian Broadcasting Corporation in Montreal. I wanted to take a couple of minutes, if I could, just to touch on some of the points that were raised by the panelists. The question of having a sort of uber person in charge of all document or FOIA requests for the state of Vermont or for any government, I think has some potential for problems, because you then could have a choke situation where that one person is able to control access across government. I would have some concerns about that. I was very appreciative of the comments of Victoria with regards to the New York Times and its history of having, I'm not surprised, all the litigation that it is engaged in, or having the most litigation. I think that goes to the point of deep-pocketed institutions having the resources and the intentionality to go forward on these things, because when you are reporting a story, one of the issues that you run into is desk fatigue with the time that it takes to get information, and the lack of interest perhaps from editors or assignment people who are saying, well, we're still waiting on this. We can't afford to have you be doing this story for such a long time. And of course, the more document dumping that goes on, the more you have to be sifting through to try to get the job done. That takes me to issues slightly related to FOIA, which are, for example, search warrants, which have very important public interest matters that could be contained in them. These, of course, are documents prepared often by police to justify the work that they want to do in their ongoing investigations. And what is my experience in that has been is that as search warrants are becoming more fodder for public attention, we are then getting sealing orders that are granted almost willy-nilly. Last point I wanted to make was the education one, which was referred to by Lynn, which I think is extremely important when it comes to the courts. There are many judges who do not have sufficient insights into how the law, it's odd perhaps to say that, but in the law of media access or public access or the public's right to know, constantly need to be refreshed or reminded or explained what the issues are, and they can be turned around. But it was a constant surprise to me how frequently that was an issue that we would run into as we were trying to report various stories. Thank you.
Thank you. I think that's a wrap. We have plenty of goodies over there and coffee, so please take your time and mingle.